Parliament's Legal Services has advised the Section 194 committee not to call President Cyril Ramaphosa to answer questions on the suspension of the Public Protector Busisiwe Mkhwebane. Her legal team had written to the committee's chairperson requesting that they summon the President to appear as a witness to provide oral evidence under oath. Newzroom Afrika's Athi Mtongana joining us live now from Cape Town. Athi, good morning to you. The Democratic Alliance was always suspicious to say that Parliament appears to be protecting the President, and that allegation directed at the Speaker. Are you able to tell us whether this latest news will likely lend some credence to what the Democratic Alliance has been complaining about?
Well, Xoli, I want to take you back to the time that the Public Protector's Legal Counsel wrote to President Cyril Ramaphosa. As per the directives of the Section 194 committee, they are instructed through the directives to first write to whichever witness that they want to come and provide oral evidence before the committee. And after that, they then ask the chairperson, that is in the event that that particular witness has declined an invitation from the Public Protector herself. And in this case, Xoli, you will recall that when the Public Protector wrote to the President saying that the suspension that he effected was in breach of Section 96 of the Constitution and that it was in conflict of interest, considering the investigations in the Office of the Public Protector around the Palapala Farm Gate scandal, as well as the charges in relation to the CR17 campaign and the Bosasa case, which were a subject of the reports that the Public Protector released. And so upon writing to the President with some of those issues that they raised, the President subsequently declined that invitation to voluntarily appear. And so the next step, as per the directives of the committee, was to then write to the chairperson to say that this particular witness, and in this case the President, has refused an invitation to come and appear. And therefore we're asking you as the chairperson of the committee to then issue a summons for him to come and appear. And so what the chairperson has done then is to write to Parliament's Legal Services to say what should they consider in terms of the legalities that surround this particular matter. And so we've heard today from Parliament's Legal Services that the President does not need to come and appear to answer questions, particularly in relation to the Public Protector's suspension, which she is of the view is in conflict of interest and in breach of Section 96 of the Constitution, and that he does not need to come and appear to answer anything insofar as the court processes that are currently unfolding. I also want to read to you some of the sections that were read out by Fatima Abraham, who's the lead there at Parliament's Legal Services. She says that Parliament's Legal Services, the President in particular, Xoli, was the subject matter of the CR17 report. He was not involved in the investigation or the drafting or the issuing of the CR17 report, and that in that process then that is ultimately to be scrutinized by the committee. She further said that the President's version in relation to the events that led to the complaints against him and the subsequent challenge to the report forms part of court records and is contained in sworn affidavits. And so they're saying that the President has already dealt with this matter through deposing an affidavit with regards to what his version is with regards to the funding of his presidential campaign, and that the courts have already dealt with this particular issue. And so it is on those grounds that the Parliamentary Legal Services is saying that the committee does not then need to call the President or summon him to come and answer the issues that have been raised by the Public Protector, because in essence what they're saying is that any witness that appears before the Section 194 committee needs to be one one that would actually help them with information that will determine the veracity of the charges that have been leveled against the public protector. But then on the other hand, you have the public protector arguing then that because of some of these charges that have been leveled against her, which include her investigation into the CR17 campaign, therefore the president needs to come and appear on those grounds, as well as the issue of the suspension. But this is then something that Parliament's Legal Services says the president does not need to come and provide oral evidence about, particularly insofar as the suspension, because that is not the prerogative of this committee. And in the issue of the CR17 campaign, that particular report was dealt with by the courts.
Has there been reaction, Athi, from the Busisiwe Mkhwebane camp?
Well, there hasn't been reaction, Xoli, but obviously we do anticipate Advocate Dalimbofu to obviously express their view insofar as this decision by Parliament's Legal Services. I need to also note to you, Xoli, that Parliament's Legal Services says that in the event that the committee is of the view that the president's presence before it is necessary, it advises that the committee, in the spirit of cooperative governance, does not then first issue the summons to the president, but rather first invites him to come and appear, saying that the summoning of the president should be a means of a last resort. And so some of the MPs already, by the likes of the Good Party's Brett Herron, already indicated that this advice by Parliament's Legal Services is something that they first need to consider as a committee, because this is legal opinion. And then they, as the committee, need to then make a decision as to whether they take this opinion by Parliament's Legal Services and move with it. Some of the MPs, most of the MPs, of course, in the ranks of the African National Congress, have agreed with this opinion that they've been given by the Parliamentary Legal Services. However, like I said, the Good Party's Brett Herron is one of the MPs who said that, well, this particular advice is not necessarily saying that we should do as they say, but it is legal advice on how they should move. But other MPs are of the view that because they have time frames with regards to when they need to finish their work, they need to move very quickly. There was also a suggestion and a letter to the chairperson to call other witnesses, Mr. van Locherenberg, for example, and Mr. Pillay, who've already given testimony before the committee. The MPs are of the view that they should not be called back to the committee because they are working around executing their work and finishing their work by September, which is next month.
Athi Mtongana, thank you very much for that update. Interesting times for our Parliament.